Then we'll go ahead and call number 53280 regarding Anthony P. Griffin. Mr. Wagnon, you announced for 20 minutes. Would you like any of that time back at the end for rebuttal?
That's fine. If I can just get a 5-minute warning, that's really all I want. All
right, we'll make a note of that. And Ms. Salcetta, is your announcement still 10 minutes? All right, thank you. Mr. Wagnon, you may proceed.
I represent Anthony Griffin, and we're here today because in October of 2013, in a panel proceeding, he was found to have violated Rules 101B1, neglecting a legal matter, 103.A or 101.03A, keeping a client reasonably informed, and 1.15D, upon termination of representation. The substance of the finding, I believe, is that he didn't return an unearned fee. Mr. Griffin, who's in the courtroom today but has elected to remain in the audience, is a 35-year lawyer. He takes hard cases. He is an activist civil rights lawyer living and practicing in Galveston County. He, as the evidence is in the record and you see, he has a disciplinary history. There are a series of non-refundable retainer cases that are ongoing. But the testimony the record shows that he handles his cases in a certain way. He's very selective on the cases that he takes. He handles them in the manner he handles them so as to make sure that the client is taken care of and that he doesn't essentially get his time wasted, I guess is a fair way to say that. On the other hand, we have a complainant who was a business owner who sold her business without legal representation. It didn't turn out the way that she wanted it to turn out. She hired a law firm that backed out on her. She spent the next year looking for another lawyer to take her case because nobody wanted to take her case until Mr. Griffin did. And then we have a situation where when it didn't go the way she wanted, she got upset and became a dissatisfied client. And the question the point that we make is there is a difference between a dissatisfied client and professional misconduct. With respect to the 101B1 neglect, the evidence at the trial and the record is reflected that over a period of about 5 months, he met with the client a few times, and that at the end of that 5-month period of time, the case hadn't been filed, she was upset and she fired him. Okay? The evidence also at trial was that this whole time period that Mr. Griffin was waiting on information from her to be able to complete the case, finally. He was going to file a lawsuit, try to get her lien validated, which hadn't happened when she did it herself, and he needed the payoff figure. The record also reflects that during this time period, he was also defending a murder client in Louisiana. The record reflects that during this time period in question, he was going to Louisiana 2-3 times a week, 8-hour drive round trip, and trying to handle that matter over there. The brief of the commission in this case reflects that the trial was only 2 weeks, and so that can't be an excuse. But I've never tried a murder case, but I would suspect that there's a whole lot more work that goes on in a murder case than just trying the case for 2 weeks. So we had back to the 101B1 neglect. We had a client that was frustrated about the delay, not just the delay with Mr. Griffin. I think that was probably the final straw. There was a delay of the lawyer that she hired in 2010 and the year delay before she found another lawyer. I think the standard, I know the question's coming, the standard is the substantial evidence standard. I do think that's correct, but I also would suggest that that whenever the facts that are in the record are not, bullet point conclusive, that you got to look at the whole circumstances, everything that's going on. With respect to the neglect, there is no evidence in the record that Mr. Griffin had a conscious disregard of this client, that he was sitting here thinking, I'm not going to do her work. The evidence is, I'm waiting on information from her so I can complete the filing.
Mr. Wagner, what evidence is there in the record that, as opposed to just waiting to hear from her, that he was affirmatively following up with her and saying, I can't do anything until I get this information? Is there anything like that?
That's a fantastic question, and there is not any record in there that says that he was sending her emails or making phone calls. There isn't anything that shows, there is no documentation that shows that he was actively seeking her out. There is evidence that she had been calling into the office. There's some email exchanges, 3 and 4 months in, but over the entire course, there is not anything in the record.
Would it be fair to say that he was aware or should have been aware that this was important to her? I say important in the sense of that she was continuing to follow up on it, and if he couldn't get to it because of his other matter, did he have some obligation to say to her, I just can't do this, I'm tied up, you need to go find another lawyer?
In those circumstances, yes. I think if it was to the point that he believed that he couldn't handle it, I think it's more of a fact that in his mind he probably had asked for information and was, until he got it, he was kind of hamstrung. Should he have it on his tickle file? Should he have sent an email once a month saying, hey, I'm still looking for this? Yes, probably. But there isn't anything in the record that substantiates that he did that. Anyway, back to that, I'll finish up on that point, is I don't think that the evidence that's in the record conclusively establishes that he neglected this client's case. In any circumstance, you can look back on a representation and say, maybe I should have done that different, or there's something I could have done better. It's an evolution, it's a process, and so, looking back, as I just said, should he have had a tickle file? Perhaps. But I don't think that the evidence that's in the record, considering all the circumstances and the murder trial and everything else, I don't think that it shows that he neglected this client. With respect to the reasonably informed 103A, the finding that was made seemed to be that Mr. Griffin himself didn't communicate adequately with the client. I think that there is evidence in the record of some email correspondence. They've had a few meetings, and I think a large part of that was that there were a lot of meetings missed. And the record, Mr. Griffin's testimony in the record was that a lot of times he was going to Louisiana on the spur of the moment, and things did happen where he had to miss. There's evidence in the record where Mr. Griffin's office to the complainant, where the complainant talked to the office, and there's allegations that the client or the complainant was upset because Mr. Griffin's secretary was rude and wouldn't tell her why he was in Louisiana. Well, again, that's one of those things where it could have been done better. Could have been said, I'm sorry, he's there on a case, it's a murder case or something, without revealing client confidences, and that didn't happen. And so a lot of the frustration just seems to be that they couldn't find out why he wasn't there. The biggest point, or the biggest point that we want to bring up on the 1.15D is there is a conclusion in the panel report that Mr. Griffin failed to return an unearned fee. And I haven't checked this court's docket or this panel's docket, but there is a lot of controversy over unearned fees, non-refundable fees, flat retainers. There was an article in the Texas Bar Journal not too long that tried to cut the chaff from the wheat, and I'm not sure anybody still completely understands it. But the record indicated that Mr. Griffin took this case on a $5,000 non-refundable retainer. He took that money, and essentially it was, you give me $5,000, I take your case. In addition to that, there was a contingency fee portion to this contract, that in the event he's successful and he recovers their money, he would get something else for that. Based on that, based on the contract where it says this is non-refundable, based on Mr. Griffin's testimony where he says, I explained this whole story to her, that if you hire me and pay me 80, I think that was a securities case, the analogy that he uses, if I go out and settle your case within 3 days, I still earn my fee because you paid me to do X and I've done X. And in this particular case, she was hiring him to file a lawsuit and to go after these people. And he took the $5,000 just to be her lawyer when she couldn't find anybody else to do it. So,
well, Mr. Wagner, are you suggesting that the $5,000 was paid merely to secure his availability?
yes.
The contract, which is Exhibit 1 in the record, states the consideration of the services rendered and to be rendered to client by the said law firm, the client agrees to pay $5,000. That's the retainer that we're talking about, isn't it?
Yes, it is.
And so it describes the retainer specifically as being in consideration of services rendered and to be rendered. It does not describe it, does it, as a fee to secure just the availability of this lawyer.
I agree with you. That is what the agreement does say. Mr. Griffin's testimony was that this wasn't that he used a form and it didn't weed out what it needed to weed out, but that he explained it to her. So, but what we're advocating here, or what Mr. Griffin's position is that's what it in fact was. I can't argue against what the document itself says.
The document also says that his hourly fee is $250 to $500 an hour in the civil rights arena. This isn't a civil rights, is it? No,
and as I was reading the transcript again last night, reading his testimony, well, that's not right either, because this isn't a civil rights case. And well, this, and so I do think that the Exhibit 1 was very inartfully drawn for what it was his intentions to portray.
Okay, so now my question will become a more substantive question, and that is, what is the standard review by which this board is to look at the result in this case?
The substantial evidence.
If we had nothing before us except Exhibit 1 in the record, would that form a reasonable basis for the grievance committee's decision?
If that's all there was, yes,
If that's all there was,
yes, sir.
Would that form a reasonable basis?
Yes, sir.
So you're telling us there is substantial evidence to support the result here on 115?
Well, what I'm telling you is that if you look at all the evidence, including the testimony that explains this document, the conflicting testimony of the client and Mr. Griffin, I think if you look at all of it, that I think I think that there's something that can be considered there, yes.
Mr. Wagner, I have a question with regards to the same exhibit. It's entitled, or there's a title at the top of it that says A. Griffin Lawyers.
Yes.
Are there other lawyers in Mr. Griffin's firm?
I'm going to be honest with you, and I don't know the answer to that question.
I didn't see it in the record, but you don't know?
Answer to that question. I do not believe so, but I do not know.
Because it also refers to, it authorizes A. Griffin Lawyers / Anthony P. Griffin to represent, and then it refers to lawyers throughout the document. But you know.
I don't know. This was an inherited case for me, so I don't have long history. So I just don't know the answer.
Thank you.
The last thing I'd like to point out about the entire record in this case is there was a lot of discussion when Mr. Griffin was testifying by some of the panel members who were throwing out, well, maybe shouldn't you have done this, and wouldn't a declaratory action been better, or a whole different other thing, different ways. And I don't think that that's a standard you look at to decide whether or not professional misconduct occurred, because there's 11 of you up there, and I could present a legal problem to you, and I would get a lot of different answers, I suspect. I think in the record itself, you know, there was several lawyers that looked at this case. When Ms. Redden, the complainant, left Mr. Griffin, she tried to get another lawyer who told her, hey, sorry, you know, statute of limitations is expired. But then there's more evidence in the record that the statute of limitations had in fact not expired. So, you know, I think that you look at, I just think that the evidentiary panel got way off base and submit to this panel, to this board, that perhaps because there was other things he could have done or should have done or would have done differently, that they found misconduct as a result of that. So I'm just asking that this panel look at all the evidence and the totality of the circumstances and reverse the decision of the trial panel. Thank you.
Thank you, Mr. Wagner. Ms. Laceda?
May it please the board. The evidentiary panel found that Mr. Griffin violated 3 rules with respect to his representation of Polly Redden, as stated by Mr. Wagner. He violated 101B1, 103A, and 1.15D, and they did impose a sanction of partially probated suspension against him. Mr. Griffin has failed to meet his burden here as appellant. He has failed to show that there is no rational basis in the record to support the panel's findings. In fact, if you look at the record, it's quite to the contrary. There is a rational, reasonable basis to support each of the panel's findings. And I think that can be illustrated best by looking at each of the points that Mr. Wagner raised today, first starting with the neglect issue. There is rational basis for their finding that there was a conscious disregard on the part of Mr. Griffin with respect to Ms. Redden's representation. She did come to him asking for him to help in this dispute. She had sold her daycare and loaned part of the funds to the buyers, and they were not making payments as required. Also in the process, she explained to Mr. Griffin that she did not receive any sort of lien or anything to protect herself. The title company didn't arrange for that, and she wasn't represented by counsel. So she had specific concerns. She was concerned that in the event of some sort of natural disaster, like a hurricane or fire, that she wouldn't be able to be on the insurance or be payable for proceeds if something happened to the daycare. There was also concern that she had found out that the owners were threatening to declare bankruptcy, and that without a lien or some sort of legal declaration in the matter, she would not be able to be a creditor in their bankruptcy and be able to recoup her losses. That's why Mr. Griffin said, give me the $5,000 up front within a week, as well as your calculation of what you think they owe, when their payments, what payments they have made to date, etc. And she did that. She testified that she did that within a week. But Mr. Griffin did not file suit within a week, as he indicated that he would. He didn't file suit within 6 months. What did happen was that within the first several weeks, she called and couldn't get any information out of Mr. Griffin's staff, was told that Mr. Griffin was out of the office, sometimes in Louisiana. She was told that the staff couldn't give her any information on her case, specific to her case, as far as what was going on in the case. She asked for documentation showing what's been done on my case. Is there any documents? And they told her computers are down. We can't send you anything. So that's what Mr. Griffin didn't do. He did meet with her on one occasion when she emailed him and said, look, nothing's happening that I know of. what's going on in my case. They set a meeting, he didn't show. They set another meeting, they finally showed. That's when Mr. Griffin showed her this draft of a Liz Pendens, 2 or 3 pages, that was incomplete, that didn't include suit against the title company, which he had indicated at the beginning would be part of the strategy, to sue both the title company and the owners, the daycare. And he also gave her a 1-paragraph demand letter, which basically piggybacked on the demand letter of her previous counsel to the owners. And that's all. That's it. And yes, it was incomplete. It was not what she had asked for, and it was not progress. So she terminated the relationship and asked for return of any unearned fees.
Counsel?
Yes, sir.
Can you tell me when that meeting occurred? Do you have that?
That meeting...
Was he terminated immediately after that meeting, or was there some time lag between that meeting and the termination?
I think that meeting occurred around February, in late February, and she terminated him with the March email. And so within a few weeks, not having heard anything from him, because he did promise at that meeting, look, I'll get you a final draft. I'll get you a final draft of the pleadings. We'll do something on the case. A few weeks passed, nothing had happened, so she did terminate his services by email.
Thank you.
So that's the evidence that was before the panel. And there is more than sufficient evidence to support a rational, reasonable basis for their findings that he neglected her case, that he showed a conscious disregard for the duties owed to Ms. Redden. As far as his excuse about the criminal trial that he took, yes, the trial was only 2 weeks, and if he was out of the office a couple days a week during that time period and couldn't otherwise attend to Ms. Redden, she received no indication from him that there was any difficulty in taking her case or completing her case or doing the work, or any impetus to him filing the suit on her behalf. She also never told her that she needed to provide any additional information other than what she provided that 1 week after the hire. He could have filed suit upon receiving the information from her with the $5,000 check. He could have filed suit at that point with the information she had given on the payments that had been made up to that point. The only reason he might need additional information 6 months later is because he hadn't filed suit all that time. So if there were additional payments that had been made, then maybe that could have been brought into a suit. But that wasn't a reason for him to have not acted for all that time. Regarding the communication issue, 103A, I'd like to point out, has 2 parts to that rule. There's the keeping the client reasonably informed of the status of the matter, sort of prospectively, without whether they call or not. If there's something that needs to be done, let them know. And to promptly comply with reasonable requests for information. And here we saw evidence that he violated both parts of that rule. Ms. Redden testified that she would call and receive no status updates, nothing specific from the staff regarding her case. And Mr. Griffin himself did not return her phone calls, did not communicate with her or return her email correspondence. Having staff available to answer the phone is not enough. The evidence presented by the panel, they had sufficient evidence to conclude that by not receiving any specific updates about the case, specific to her case and the status, that was a failure on Mr. Griffin's part to communicate with her. And by not responding to her calls or to her emails, that again, that violated 103. Regarding the unearned fee, 1.15D. This is clear.
Can you explain under what circumstances a lawyer can take money as a retainer and then retain it all without consideration to the work done in connection with the representation?
Yes, sir. There may be a lot of cases on this issue lately, but the law is clear. We see it.
I hope it's clear.
We see it in. It's been set out in the Austin Appeals decision, Cluck versus Commission for Lawyer Discipline. The difference between a true non-refundable retainer and what we have in this case, an advance fee payment. For a true non-refundable retainer, it has to be a general engagement fee. It's either to secure the lawyer's availability for yet unforeseen matters, not for services to be rendered, but for their availability, and any services that might be rendered would be under separate payment, separate agreement, and to remunerate the lawyer for lost opportunities to accept other employment, such as, if I take this, I'm going to be conflicted out of that, so you need to pay me this advance retainer just so I'll represent you in this matter, or
And
you
we're
need
talking
local
about
counsel.
actual other pro-offered representation, not just,
Right.
Gosh, if I get busy here, I might not be able to take something which I cannot yet identify in the future.
That's correct. Not just as what we saw. It has to be something specific, some specific identifiable representation that you could not take because of you're taking this client. And what we saw from Mr. Griffin, he testified that his reason for wanting a non-refundable retainer is to make sure payment that they have some sweat in the game, that they're going to be serious about the matter, and that he sees it as a matter of public interest because he's making himself available to people by accepting the non-refundable retainer. However, if we look at both the contract and the facts surrounding the representation, all show that this was actually an advance fee, because the contract does contain a provision that says this is a non-refundable retainer. However, it also says that this is going to be for services to be rendered to Ms. Redden for this specific matter that she's coming to me for. Mr. Griffin testified that he wasn't going to represent her on anything else. And if she had come to him and said, look, I've got this title thing and I've also got an employment matter, he would have made her do a separate agreement. That would have been a separate representation.
Sure, and I asked Mr. Wagner the same question that I'll ask you, and that is, given the standard of review with respect to this matter, if the Exhibit 1 agreement was the only evidence before the board, would it, in your opinion, form a reasonable basis for the evidentiary panel's decision?
Assuming it was the only evidence available, then yes, it would still support the panel's findings because of the terms of the contract would state that it is for specific representation of Ms. Redden in that matter for services to be rendered, despite the fact that it says non-refundable in the contract, because the case law is clear that having non-refundable, the words non-refundable aren't enough. Okay.
Ms. Salceda, let's assume that it doesn't meet the terms of CLUC and that you're correct and that it's an advance
Yes, sir.
on work to be done. There is record evidence from Mr. Griffin saying that he earned the entirety. In fact, I believe the number was $5,800 and change based on time. Is there any record evidence to the contrary that he did not earn the entirety of the $5,000?
To answer your question, I believe the panel had the right to assess and weigh the evidence that Mr. Griffin presented, which was his own statement that he had written, not at the time of the representation, but for the purposes of the grievance proceeding, he had written out a timeline or a detailed billing what he thought he had done on the case. And the panel got to hear his testimony as to that. And they have the sole discretion to give credibility to his testimony. And if you look at the record closely, what we see when we look at the billing and his testimony accompanying it is that, except for the meeting, the brief meeting at the beginning of the representation and the brief meeting where he presented these 3 or 4 pages of incomplete information to Ms. Redden, that was pretty much it that he had done on the case. Everything else, he had claimed that he had read and reviewed. He was trying to bill her for like 10 or 11 hours of looking at the same half-inch set of documents that she had provided him at the very beginning of the representation.
Can I ask you, do you draw a distinction, because am I correct that the evidentiary panel ordered that all of the money be refunded that she had paid to him?
They did.
So that seems to imply that he didn't earn any money. Is that correct?
That's correct.
Is there a difference between not earning any of it or doing work that they didn't deem advanced the ball? let's assume, for example, because it does appear that he did some things. There was a draft of a letter and petition and all that, and we can argue among ourselves how effective it was or whatever, but I don't think there can be any dispute. He met with her and did some work. So with that in mind, what is the justification for ordering that he give back the whole $5,000? Is some of it earned?
I think because it was such a minimal amount, such a minimal effort, that the panel felt that when he tendered the $5,000 to Ms. Redden prior to the hearing, that was sufficient restitution, that's what should have been owed back to Ms. Redden.
Now that sounds like speculation to me on your part.
I can't know what their deliberations were or what their thinking process was, but the record does show that most of what Mr. Griffin did was very little at the beginning, just to secure her services before he even became hired and worked on the case. Yes, they met for a brief period of time. He was trying to charge her for drafting his contract, which is an administrative function. He tried to contract her for creating the client file, which is, again, an administrative function, and for mailing her the contract to be signed. Those things were not things that would have been chargeable as attorney's fees, and the panel had the ability to say that there's no weight that should be placed on that, as well as to question his credibility as the other charges that he claimed.
It just seems to me that there would be a difference between he took the $5,000 and did nothing versus he took the $5,000 and did some work, which we all might argue about how worthwhile it was. But I'm just wondering how you justify that with the fact that they asked or told him to refund all of it, not from a speculation standpoint, but from a factual standpoint.
I think because there was nothing that advanced the case, it was not work that was done on her behalf after being hired by Mr. Griffin.
One final question from me anyway, I think. There seems to be a lot of other cases or reprimands that were similar to this, at least on the surface. Were they in fact, I don't have much information on them other than the findings, were they in fact, in your view, similar?
Yes.
Such that this is repeat conduct?
Yes, sir. And those are in the record. If you need to look at them, there were petitioners exhibits 6 through 11 in the record.
Well, I saw the actual findings, but I'm just saying I don't have any information other than what's in the findings.
Right. They were the same rule violations. We're seeing again and again repeated violations of the 1.15D, failure to return unearned fees, and neglect. And so that was considered by the panel, as well as that because most of these, all but one of his prior discipline had occurred within the last preceding 5 years, and because they were public reprimands or greater, or probative suspensions, and involved some of the same rule violations, 1511 of the procedural rules did apply, and I think they exercised that.
When did Ms. Redden seek a refund of the $5,000?
When she terminated his services in March.
So on or about March 6th?
Yes, sir.
And the final meeting between Mr. Griffin and Ms. Redden would have been on February 27th, I think, according to the findings.
Yes.
Okay. Thank you.
If there's no further questions, then we ask that you affirm the partial probated judgment in all respects. Thank you.
Thank you, Ms. Salceda. Mr. Wagnon, would you like your last 5 minutes or so?
Your Honor, I'm gonna waive my any rebuttal time.
Okay. Thank you both very much for an interesting argument, and we will take that under consideration and advise you of our decision.